Okay, folks, contracts. This is a big one, probably the biggest one of the term. Take breaks. You can do this. I'm going to take breaks too. This is going to be a long one, but hopefully it will be clear, famous last words, and interesting, also famous last words. So in terms of what you're going to learn today, you're going to learn all about contracts, what they are, where they came from, what makes them up, how we enforce them, what happens when you breach them, all kinds of stuff. But let's start simple. Let's start with defining what a contract is. A contract is simply a legally enforceable promise. We need contracts in business and in life to help make things predictable. I know that if I have a supplier that's going to be shipping me 60 cases of water every week for my school to give to my students, that I will have water to give to my students on Tuesday morning or whatever the day after each shipping day is. I know that if I have a contract with the air conditioning repairman to come service my air conditioner twice a year, that he's going to be there consistently twice a year. And so it is a really important concept that keeps, for lack of a better word, the trains running on time in business. Contract law comes from a variety of different places. Most prominently, common law and the UCC common law. So there's lots of types of contracts: express contracts, implied contracts, promissory estoppel, quasi-contracts, all crafted over centuries by courts deciding one contract lawsuit at a time. Because contract decisions could be inconsistent across states when you're looking at interstate commerce, in 1952, many of the states got together and created what's called the UCC, or the Uniform Commercial Code, which is a body of law that governs the sale of goods. And the UCC is used in whole or in part across all 50 states. California, I believe, has adopted the UCC in its entirety. Restatements of contracts. The legal restatement of contracts is a legal treatise which seeks to inform justices and lawyers about general principles related to contract law. International contracts are influenced by sources like the CISG, which is the UN Convention on International Sales of Goods. Lots of different sources influence our modern day contract law. So I just mentioned the UCC. The UCC specifically governs the sale and leasing of goods, negotiable instruments, bank deposits, letters of credit, investment securities, secure transactions, and other commercial matters. And like I said, every state has adopted at least part of the UCC. For our purposes, we're mostly going to be talking about the UCC with respect to sales of goods. So when we look at the different types of contracts, there are really three types. There is a contracts for services. So contracts for services are going to be contracts for a service that's provided. So when you go to a yoga studio, that is a service. When you go and purchase a bottle of water, that is a good. So contracts for services are governed by common law. Contracts for sales of goods are governed by the UCC. And then sometimes we have contracts that involve both a good and a service. So I go to Best Buy and I go and I buy a laptop computer. And when I buy the laptop computer, they invariably are going to ask me, do I want the service plan with that? The sale of the computer is the predominant purpose of the purchase, because would I just buy a service plan without buying something that goes with it? No. And so in that case, I have a good, the computer, and a service, the service plan. And so in that case, that contract is governed by the UCC because the predominant purpose is the sales of goods. Let's say that I have a plumbing problem in my house. And so I call a plumber and the plumber comes out and he says that he needs to repair a leak and it's going to be so many dollars for the service and the parts and labor, okay? The predominant purpose of that contract is the plumber's service, not the parts and labor. I wouldn't buy the parts not knowing what to do with them. The labor is the predominant purpose. So that contract, also a mixed contract, would be governed by common law. So mixed contracts, you have to look to the predominant purpose to know which law governs. In looking at contract taxonomy or contract vocabulary, there are a lot of ways that we a lot of terms that we use to describe contracts. An express contract is a contract where the two parties explicitly state all of the important terms of the agreement. If I am buying a car, for example, all of the terms of that car sale are going to be in the agreement. It's going to be a written agreement, and it's going to state everything very clearly. What's included, what is not included, the price, the day that I'm buying the car, how long the car is warranted for, all of that. An implied contract is where words and conduct indicate that the parties intended to make an agreement. When I go into a restaurant or I go into McDonald's and I see something on the picture on the menu, and I look at that and I point to it and I'll say, I'll have that. Whatever it might be, let's say it's a Southern chicken sandwich. What McDonald's provides me when they hand me my plate of food should look like the picture, because there is an implication that what I am getting is what I'm seeing. And if it is a Southern chicken sandwich, it should probably taste how a reasonable person would assume a chicken sandwich tastes. So that is an example of an implied contract. Most of the contracts that we enter into on a day-to-day basis are actually implied contracts. When we think about the contract itself, a contract can be bilateral, where both parties are making a promise, or unilateral, where one party makes a promise that the other party can accept by doing something or not doing something. An example of a bilateral contract might be when I go to somebody who I'm gonna do business with, and I say, hey, Clarissa, I need somebody to water my plants and to take care of my cat for the next 2 weeks. Are you willing to do this? And Clarissa says yes. And I say, okay, then let's plan on you coming by 2 days a week, and I'll pay you $50 each time you show up. That is a bilateral contract. It's actually bilateral and express because we've just laid out all of the important terms and conditions. A unilateral contract is where one party makes a promise and the other party can accept only by doing something. Hey, Clarissa, I'm going to be gone a couple of days. My plants need water. If I come home and my plants are still alive and freshly watered, I'll give you $50. If I come home and my plants aren't watered and you haven't shown up, I'll give you nothing, and I'm going to go to Home Depot and buy some more plants. So I've made an offer to Clarissa, and she can accept that offer by coming over and watering my plants. She doesn't have to make a promise back. It's the action that she's going to do that implies that she is taking the deal. So bilateral, there are two promises. Each party makes a promise to each other. Unilaterally, one party makes a promise that the other party can accept by doing so. Sometimes you have situations where the court will make contracts where there was none in the first place. This is referred to a process called promissory estoppel, or the plaintiff has to show that the defendant made a promise knowing that the plaintiff would likely rely on that promise. The plaintiff did rely on that promise, and the only way to avoid injustice is to enforce the promise. I worked at one point with someone who our employer promised them if they stayed at the company would implement a 401k employer contribution sharing plan. Because of that, the employee chose not to take a job at a competitor. Our employer explicitly asked the employee to stay, and the employee said, well, I really want to, I love this job, but the other people have a 401k program where there's matching and we don't. And so they said, okay, well, if you stay, we will implement 401k match. So the employee stayed. A year later, they had not implemented that match. They didn't implement it 2 years later. And ultimately, when that employee was laid off, they sued for damages based on the fact that they turned down this other job because the employer promised 401k match. That was a promissory estoppel. We also have quasi-contract. And quasi-contract happens when there is a benefit that's given to the defendant, and the defendant knows that the plaintiff reasonably expected to be paid for the benefit, and the defendant would be unjustly enriched if they didn't pay. Those damages are called quantum me ruit, meaning the plaintiff gets as much as he deserved. So let's say that I'm a house painter and I'm called to paint this house on the street. They say, show up at 8:30 on Monday. It's the third house on the right. Well, I go to the fourth house on the right and I start painting it, and the homeowner comes out. They see me setting up the painting stuff. They see me painting their house. They know that they're getting the benefit of a freshly painted house. They like the way that the paint looks. And so when I go at the end of the day to knock on the door and say, okay, thank you, I'm ready to collect my money. And yes, I know it's stupid of me to just go start painting a house. This is an example. I go to collect my money and the other person says, well, I never asked you to paint my house. Well, that's an example where I can go to court and ask the court to compensate me for painting the person's house. I'm not going to get the full contract price. What I am going to get is maybe recompensed for my materials or some of my labor, something. I will get quantum me ruit damages as much as I deserve. Okay, moving on. Let's talk about how contracts are formed. And really, there are 5 elements that you need in order to form a contract. First of all, you need to have agreement. One party has to make a valid offer that the other party has to accept. There has to be bargaining that leads to an exchange. This is referred to as consideration. The contract has to be for a lawful purpose. Both parties have to be adults of sound mind, and they have to consent to make an agreement. In certain cases, contracts need to be written in order to be legally enforceable. I will talk about that in a few minutes. But if one of those elements is missing, then there is no contract. So elements of a contract: agreement, consideration, legality, capacity, and consent. Okay, moving on to agreement. So the parties can only form a contract if they have a meeting of the minds. That means that they have to understand each other and they need to intend to reach an agreement. What is agreement? And how do we know that we came to an agreement? Well, that's really up to the judge, who's going to make an objective assessment of disagreements about whether or not a contract was made. And really what they go to is what's called the reasonable person standard. And in this case, that would be whether or not a reasonable person would conclude that there was an agreement based on the party's conduct. So let me show you how agreement works. So let's take a look and see how this works. Let's say that I come up to you and I say, hey, do you want to buy my cat? And you think you love cats, and so you think, yes, I would love to buy this cat. How much do you want to sell it for? And I say, well, I really need to get rid of it, so $50, come to my house, and the cat is yours. And so you get your $50 together, you come to my house thinking that you're going to get one of these cute little things. And instead, I take you around to my backyard and I say, okay, here's the cat, $50, it's all yours. Now, first you might be thinking, why on earth would she sell a Caterpillar tractor, a cat, for $50? And the doesn't matter. We'll talk about that when we get to consideration. But you're thinking that you're getting a cute little kitty cat when I am talking about a Caterpillar tractor, also known as a cat. And right there, we don't have a meeting of the minds because we don't understand what we're bargaining for. You think it's one thing and I think it's something else. So right away, no contract. So when we look at agreement, what we're talking about is offer and acceptance, okay? And the offer has to be an act or statement that proposes definite terms and permits the other party to create a contract by accepting those terms. Some important caveats: an invitation to bargain is not an offer. A price quote is generally not an offer. An advertisement is not an offer. And if you're placing an item up for auction, that's not an offer either. It's merely a request for an offer. And when the auction closes, you have an offer. The terms of the offer have to be definite. There's really no room for vagueness. If the offer is vague, then the judge will assume that a reasonable person would expect that you didn't mean to make it. Under the UCC, you can have some wiggle room for vagueness. So again, UCC, we're talking about sales of goods. And we know when people are selling goods, especially if they're selling goods in vast amounts, goods are being manufactured. We don't always have firm information in real time. And so the UCC allows for something that's called open price. And so open price means that you can say, I'm going to sell 1,000 lobsters at market price. That would be an open price. Two types of contracts: output contracts and requirement contracts. Sometimes you don't know how many of an item you are going to be able to sell or you're going to buy. And so what you might say is, I am going to sell 100% of what I produce. That's referred to as an output contract. A requirements contract, on the other hand, is when the buyer says, I will buy 100% of what I need from you. And the reason for output and requirements contracts is, like, let's say, for example, that you're a farmer and you have a field of strawberries. You can plant 1,000 seeds, but that doesn't mean that you're going to get 1,000, your yield is going to be 1,000 berries. Your yield might be 500 berries, it could be 750, it could be 1,100. And so rather than commit to a specific number, what you say is, we will sell all of the berries grown in field XY. And that satisfies the requirement for the amount of berries. So output contract, selling 100% of what you produce. Requirement contract, purchasing 100% of what you need. Delivery time and payment. If you don't have specific information there, the law assumes that delivery is at the seller's place of business. The seller is required to get it to their loading dock. Time has to be reasonable for that industry. Every industry is different. For some, it might be 2 days. For some, it might be 2 weeks. For some, it might be 2 months. And then payment, if nothing is said about payment, the law assumes cash on delivery. So sometimes you may need to terminate an offer, change your mind, something happens. So how are offers terminated? Well, if you revoke an offer, I decide that I'm going to sell my cat, and then I change my mind. If I change my mind before you say yes or no, then the termination is effective. Okay? If you reject my offer, that immediately terminates the offer. If you make a counter offer, if I say I will sell you my cat for $50 and you say I'll give you $25, that counteroffer technically is a rejection and it terminates the offer. I could turn to the next person and say, I will sell you my cat for $50. And if that person says yes, even if you were just trying to negotiate with me and you really wanted the cat, you're out of luck. If there is a specific time limit for acceptance, that time limit is binding. If the offer says this offer is good for 24 hours, hour number 25, offer is terminated. If there is no specific time period, the offeree has a reasonable period of time in which to accept. What's reasonable? Again, different for every industry. And by operation of law, death, incapacity, or destruction of the subject matter terminates the offer. Okay, the offeree has to do something to accept. They have to say something, they have to do something, they have to accept the offer. In a bilateral contract, remember that's when both parties make a promise, the offeree generally has to accept by making a promise. In a unilateral contract, the offeree accepts by performing, doing whatever it is that the offerer was asking the offeree to do. We have something called the mirror image rule in common law, which means that you have to accept on precisely the same terms as the offer. So if I am selling 500 lobsters and you accept 250 lobsters, you haven't technically made an acceptance. If the offer demands acceptance in a particular medium or manner, the offeree must follow those requirements. If I say that the only way that you can accept my offer is by sending a clown who's going to do a singing telegram at my front door at 9 o'clock on Tuesday, that's how you have to accept the offer. If the offer doesn't specify any type of acceptance, the offeree can accept in any reasonable manner and medium. In terms of time of acceptance, we have what's called the mailbox rule. And what it says is that an acceptance is generally effective on dispatch, meaning the moment that it's out of the offeree's control, they have accepted the offer. So if you're accepting by email, you hit send, you've accepted the offer. If you are accepting by mail, goes in the mailbox, it's technically out of your hands, you are accepting the offer at that moment. Consideration is the inducement, the price, or the promise that causes a person to enter into a contract and forms the basis of exchange. And consideration can be anything that someone might want to bargain for, a cat, for example. And so in looking at that bargain and exchange, you can exchange for something that has any kind of value. That can be an act, so an action that a party wasn't legally required to take in the first place, and I'm inducing you to take that or make that action or take that act by virtue of payment. It can be forbearance, which is refraining from doing something that you have a legal right to do. Could be you are agreeing not to open a specific kind of business for a certain number of years. That would be a forbearance. In order for consideration to be adequate, it has to provide some benefit to the promisor or some detriment to the promisee. So it's got to be something worth bargaining for. Does it matter that I'm selling a giant tractor for $50? No, the courts do not look at the adequacy of consideration. They just look to see that there was consideration made. Why is that? I'll talk about that in a minute. So something that you have already done is not consideration, okay? We refer to that as a previously paid benefit. An exception is if parties agree in advance that something that you've done in the past is valid consideration. Sometimes we have promises that are conditional. We refer to those as illusory promises. I will sell you my watch for $50 if I decide to sell it. That if induces vagueness into the deal, and courts don't like it when things are vague. So that illusory promise is not consideration. And with outputs and requirements contracts, again, consideration can be whatever the output is or 100% of what I require. A pre-existing duty, something that you've already promised to do, is not consideration. If I say to you, hey, come play my nightclub for $500, and you say, yes, I will play your nightclub for $500. And then the day before the concert, you raise the price to $1,000. I say yes, and I pay you the $500 and you sue me for $1,000, I'm gonna win. And the reason for that is because you already agreed to the deal at $500. If the scope of the promisor's task increases, then you can increase the consideration. So if I say to you, $500 for 10 songs, and then the day before I say, no, it's actually 20 songs. Well, the scope of your task has increased and you can raise the price. Unforeseen circumstances, if there are unforeseen circumstances that cause a party to make a promise regarding an unfinished circumstance, that promise is valid consideration. In English, what that means is, let's say that I hire somebody to come over and remodel my house. And they're tearing apart my kitchen, and they realize that there's something wrong with my foundation and I need to have an entirely new foundation put under my house. Also something that would never happen. I have really weird examples sometimes. Those unforeseen circumstances allow the contractor to make that change in price, okay? So if there's unforeseen circumstances, the consideration can change. If both parties agree to cancel a contract and then form another one, the new contract is valid. And a modification of a sales of goods contract is allowable without consideration, unless there is a written agreement that forbids modifications. And sometimes in contracts, you will see a clause that prohibits modification unless in writing. Okay, so we've talked about agreement, we've talked about consideration, let's talk about legality. Frequently, you might have business arrangements where somebody has a territory. So you buy a franchise for, let's say, a personal training business. And the franchise says that you have the city of Oceanside or the city of Carlsbad. Well, what that means is that you are allowed to do business in Oceanside, not Carlsbad. And so in order for a restraint of trade clause to be valid, it has to be ancillary to a legitimate bargain. Sale of business. Let's say that I have a pizza business and I decide that I want to get out of the pizza business, so I sell the business. The buyer has the right to ask me, as part of the sales agreement, not to open a competing pizza business within a 5-mile radius for 5 years. Makes good sense. It is ancillary to the sale of the business. A customer could easily, from my old business, come to my new business. And so that kind of defeats the purpose of the guy buying my business. And so that's reasonable. If the buyer says that I'm not allowed to open a new pizza business anywhere in California for 5 years, well, that is not reasonable in geographic area. And so, or an Italian restaurant in California, that's not reasonable in terms of the scope of activity. Because I sold a pizza business, I should be allowed to open another kind of. So a non-compete has to be reasonable in time, area, and scope. What is reasonable? That is going to depend on the type of business that is being sold. Employment. Sometimes you have an employment contract where your employer says, you are not allowed to go and work for any of our competitors. That's a non-compete clause. With a non-compete clause, it's generally enforceable only if it's essential to the employer, fair to the employee, and harmless to the general public. If somebody is a scientist who is working on the cure for Alzheimer's disease, and they're close, and a competitor hires them away, no non-compete clause is going to work against that employee, because that knowledge that that employee has is something that could potentially help humanity. So something like that is not going to be legally enforceable. Sometimes we have contracts that might violate statutes. Gambling contracts are only legal if they're allowed by state statute. Insurance policies. An insurance policy is only legal if you have an insurable interest in the person that you are insuring. I cannot take out a life insurance policy on one of my students. I can take out a life insurance policy on my husband. Licensing statutes, I'll talk about those in a minute. Usury is the act of charging too much interest, and credit card interest has to be capped. I think it's now capped at like 30%, which is way too high. An exculpatory clause is a clause that attempts to release you from liability to or injury to another party. When you buy, I think about like baseball tickets, when they actually used to print out the ticket, you flip the ticket over and it generally says, there's generally a bolded box that says, this limits our liability, read this limits our liability. And basically it tells you that if you get hit in the head by a baseball, it's not their fault. That is an exculpatory clause, and that is legal. Generally, exculpatory clauses are unenforceable when the activity is in the public interest, such as medical care, public transportation, or some essential service. Your doctor cannot say, I am not liable for malpractice if I screw up on your surgery, because that is an activity that is in the public interest. There is a public interest in doctors doing their jobs well. Exculpatory clause that excludes an intentional tort or gross negligence is not generally enforceable if the parties have greatly unequal bargaining power, and if the exculpatory clause is not clearly written and readily visible, it is not generally enforceable. So again, an exculpatory clause is going to have like a big bold box around it. It's going to be in bold, and it's going to say something like, read this limits our liability. Licensing statutes, sometimes you have licensing statutes that protect the public. Doctors, CPAs, lawyers. And so any contract made by an unlicensed worker is unenforceable if they are doing work that requires public licensure. If, however, it is a licensing requirement that is simply designed to raise revenue, a contract made by an unlicensed person is generally enforceable. A business license in many cases is a revenue-raising license. So if, for example, I have a legal dispute with a business that is unlicensed, and I go to court and I sue the person, basically what the court's going to do, and I say they don't have a license, I didn't know that they didn't have a license, and I should win this lawsuit. Basically what the court's going to do is they're going to hear the argument. They might side in the other party's favor, but what they do when they side in the other party's favor is they're going to say, in order for you to collect whatever you're going to collect, you need to go and get a business license. Show it to the court, and then we will allow you to collect your whatever it is that you're collecting. Sometimes courts refuse to enforce contracts because of fundamental unfairness. There are two factors that lead to unconscionability. The first is oppression, meaning that one party had way more power than the other party, and it used that power to force the other party to do something, or surprise. And surprise is basically that, again, two parties, greatly unequal bargaining power, and the weaker party didn't fully understand the consequences of the agreement. Moving on, capacity as our next element. Capacity is the legal ability to enter into a contract. And generally, folks who lack capacity create voidable contracts, and they can be canceled by the party who lacks capacity. Minors lack capacity due to age. So minors typically can disaffirm a contract, meaning that they can notify the other party that they refuse to be bound by the agreement. A minor who does disaffirm the contract has to return the consideration to the extent they are able. And they can do this anytime before they turn 18 or a reasonable time after they turn 18, as long as they have not ratified the agreement. If I sell my car to a 16-year-old and the 16-year-old goes out and drives it for a week, maybe blows up the engine, and then brings it back to me and says, I don't want this car, here's the car back, see you later, that's on me. That's not on the 16-year-old. They can do that. They only have to return the consideration to the extent they are able. Let's say that they're making payments to me, okay? And they drive the car, they use it till they turn 18. Once they make one payment after they've turned 18, they have ratified the agreement. So at that point, they can't come back and say, I bought this car when I was 16. Even though I've turned 18, it's only been a month. I don't want it. They've already ratified the agreement. One of the exceptions for minors is contracts for necessaries. Necessary is something that is essential to the minor's life and welfare. So food, shelter, things like that. On a contract for necessaries, the minor has to pay the value for the benefit that they've received. So minors have to pay for contracts for necessaries. Some states will not allow a minor to disaffirm a contract if they have lied about their age. Also, if they're lying about their age, it's fraud. I've had many students misrepresent their age to get like gym memberships and things like that. When you try to get out of that deal as a minor by saying, oh yeah, I was a minor when I signed this, and I lied about my age. Well, you lying about your age puts you on the hook for fraud. A person with a mental illness or a mental disability who is unable to understand the nature and consequences of their transactions generally also creates a voidable contract. But folks who lack capacity in this manner have to return consideration. If they can't return the consideration, they are bound to the agreement. The reason for that, the reason why minors can only return consideration to the extent they are able, and folks with mental illness or disabilities have to return consideration no matter what, is because the law assumes that an adult can see a minor coming. And so if I make a deal with a minor, that's on me as the adult, not using good sense. You cannot see a mental illness or disability. And so because of that, the law grants a little bit more leeway to an innocent business person who doesn't realize that they're dealing with somebody who might lack capacity. Intoxicated people, when an intoxicated person makes a contract, it is voidable. Courts are very skeptical of intoxication claims, and the intoxicated party must make restitution. When we say intoxication, most people think that California 0.08, 2 drinks and you're intoxicated. That's not what we're talking about here. With contract law, we're talking about intoxication where you are so hammered that you don't understand the consequences of your actions. So it's not 0.08, it's like falling off the bar stool drunk, okay? Not able to understand what it is that you're agreeing to. Sometimes we make mistakes. Sometimes we are lied to. Regardless of whether it's innocent or fraudulent, it's misrepresentation. Innocent misrepresentation basically means that the owner makes a statement that they believe to be true and has good reason for that belief, but they're wrong. And then fraudulent misrepresentation means that the owner knows that the statement is false, but they're making it anyway. In both cases, the wronged party or the party who has been misrepresented to, for lack of a better word, has the right to cancel the contract. Sometimes they can cancel the contract and sue for damages. So fraud happens when a party to the contract represents something that they know is factually false. The injured person has to know, first of all, that the defendant knew that the statement was false, or that they made it recklessly without knowledge of whether it was false or not. Someone's opinion and puffery don't count. If you're buying a car and the salesperson says, this car is so hot right now that in 5 years it's going to be worth double. That, one, is their opinion, and two, they're saying that to help try to get you to buy the car. That's sales speak, also known as puffery. So, opinion and puffery don't count. False statement needs to be made. The false statement needs to be material to the deal, which means that because of the statement, it's one of the reasons why you're making the purchase. If somebody sells me a car with 10,000 miles on it, and I'm buying the car for the low mileage, and then I find out the car actually has 100,000 miles, well, that 10,000 miles, that lie, is material to the deal because I'm buying the car for the low mileage. And then the third element of fraud is that you justifiably relied on the statement. You're relying on the other party's word that whatever they're saying or asserting to is true. So remedies for fraud: generally, the injured party has a choice of rescinding the contract, suing for damages, or in some cases, they can do both. With innocent misrepresentation, you haven't committed fraud. Either way, the injured party has the right to rescind the contract, not sue for fraud. Sometimes you have mistakes. Mistakes can be made by one party, or mistakes can be made by two parties. A bilateral mistake is when both parties negotiate based on the same factual error. If the parties are negotiating based on the same factual error, then the contract is voidable by the injured party. And if you think about it, if two parties are negotiating based on an error, you really don't have agreement. Going back to my cat example, I'm thinking it's one thing, you're thinking it's something else. We actually don't have a meeting of the minds. If you are negotiating for something based on conscious uncertainty, if you know that you're taking a risk, if you're buying a piece of land for the mining rights below, and it turns out that there's nothing, nothing to be mined. You think you're buying something because you think that there's gold there, and there's no gold. Well, that's on you. You took a risk. And because you took the risk is on you. You don't get to rescind the deal. Sometimes only one party enters into the contract under a mistaken assumption. That's referred to as a unilateral mistake. For unilateral mistake, the party has to demonstrate that they entered into the contract based on a factual error and that one of the following applies. First of all, enforcing the contract would be unconscionable. Second, that the non-mistaken party knew of the error and didn't correct it. Or three, the mistake is mathematical or mechanical alone. So if only one of the parties is negotiating based on mistake, it is much more difficult to rescind the contract. Duress is an improper threat made to force the other party into a contract. If one party makes a threat that causes the victim to enter into a contract and the victim had no reasonable alternative, the contract is voidable. Duress can be physical or it can be economic. Economic duress, meaning that money is being used in order to force you into an agreement. And so for claims of economic duress, courts look at acts that have no legitimate purpose. Are you buying something that really doesn't make sense, that doesn't have like a legitimate business purpose? Parties that have greatly unequal bargaining power, an unnaturally large gain for one party, or financial distress for one party. Undue influence, similar to duress, but undue influence, there's a relationship involved. So there is a relationship between two parties of either trust or domination. Trust meaning maybe your lifelong friends, maybe your family members. Domination, employer, employee, something like that. So you have a relationship, and then there was improper persuasion by the stronger party. So that is undue influence. Moving on. Sometimes we have a requirement for writing. The Statute of Frauds basically says that the 6 most important types of contracts need to be in writing in order to be legally enforceable. That is any interest in land, so buying or selling property, service that cannot be performed within 1 year. So maybe I'm paying for photography for my husband's 50th birthday. That's going to be in a year and a half. I don't know why I would pay for photography that early. To pay the debt of someone else, a promise made by the executor of an estate, promises made in consideration of marriage, and any contract for the sale of goods over $500. So what does the writing have to include? The contract or memorandum must be signed by the defendant, so you need to have the defendant's signature, and it has to state with reasonable clarity the name of each party, the subject matter of the agreement, all of the essential terms and promises. Anything that's vague will make the writing unenforceable. If you're selling a car and you don't include the price, that's unenforceable. Incompleteness. If only part of the transaction is documented, then the writing is unenforceable. And an e-signature is a legitimate signature. So do you need a written contract? Yes, if the Statute of Frauds requires it. If the deal is crucial to your life or business, get it in writing. If the terms of the deal are complex, or if you don't have an ongoing relationship of trust with another party. Oral agreements are absolutely valid unless the Statute of Frauds requires it. Now, just because you can have an oral contract, should you have an oral contract? No. Always, if it's something that is important enough for you to potentially file a lawsuit over at some point in the future, get it in writing. So who drafts the written contract? Generally, both sides would prefer to be the drafter. Generally, it is the more powerful party that winds up drafting the contract. Why would you want to draft the contract? Because you get to put in all of the essential terms that favor you. So the party that is going to draft the contract is going to be the party that has the advantage. When you're renting an apartment and someone presents you with the lease, they're presenting you with something that they have drafted that includes all of the terms and conditions that they want. So if you sign it, you are agreeing to their terms and conditions. Can you negotiate? Absolutely. If you see something in the lease that you don't like, cross it out, write in what you want to write, initial it. If they initial it, it's legally enforceable. How do we read a contract? First, you read the contract by spending some time thinking about the provisions that are important to you. If you're gonna lease an apartment and it's important to you that the apartment allows pets, then you want to prioritize that. It needs to allow pets. If you want to be able to Airbnb it when you're on vacation, you got to prioritize that. Then read through the agreement. Get the basic idea of the contract. Take notes. For each of the clauses that are important, think about the various outcomes, good and bad, things that can happen. Then you're going to read through the contract again. Make sure that it handles all of your what ifs. If you are moving into an apartment with a roommate, how is the landlord treating each of the roommates? Are you each signing your own lease? Are you both on one lease? Those have very different implications if you get in some kind of disagreement and somebody wants to move out, okay? And then finally, again, If there's something in the contract that you want to negotiate, don't be afraid to negotiate it. Don't be afraid to propose different terms. They might agree to those terms. You don't know if you don't ask. So this is what a very simple contract looks like. As you can see, it's pertinent information, names, dates, addresses. Generally, you want to include an address because if a lawsuit is filed, they need to know where to go to sue. Then we get to identifying the goods. What is being sold? Okay. That next consideration, how much money? Section 3 is identification of goods. How will we know that those are my goods? If I'm buying 1,000 iPhones, what are the serial numbers? 4 is payment. Is it payment due on receipt? Are you getting 30 days? Is it 10 monthly installments? Whatever the payment terms might be. This contract, sometimes contracts have a promissory note, which is actually its own another separate little contract that is the agreement to pay in a specific way. But otherwise, that's pretty much all you need. Make sure you have 2 signatures, date each signature, and then nothing is written beyond the signatures. Anything written below the signature is not enforceable. Sometimes you might have an agreement and you're making the deal, and stuff is said, and then it may or may not get into the agreement. For example, let's say that I go down and I'm negotiating buying a new car, and the salesman really wants to sell me the car, and I really want to buy the car, but I want them to make it worth my while. And so I say, okay, I will buy this car, but you need to throw in floor mats. And the salesman says, okay. We write up the deal, and if the deal doesn't include floor mats in the writing, I'm probably not going to get my floor mats, okay? Because when you take the time to draft out a written contract, the law assumes that all of the important terms go into that contract. So if I really want those floor mats, I need to have it written in. The fact that I negotiated for floor mats and we talked about it, that's what's referred to as parole evidence. Parole evidence is anything apart from the written contract that was said, done, or written before the parties agreed to the contract. Courts do not like parole evidence. If I go to court and sue for my floor mats, the judge is going to say, why didn't you have the floor mats? I see you have this written contract. Why didn't you include floor mats in the written contract? And I'll say, I forgot. And the judge will say, well, you forgot. Clearly, it wasn't that important. 2 exceptions when parole evidence is allowable. First, if the court determines that a written contract is incomplete or ambiguous, it will allow for parole evidence. Second, in cases of misrepresentation or duress, the court is going to ask what was said or done to determine whether or not there was misrepresentation or duress. Sometimes we have agreements that were created by 2 parties that benefit a third party. If I make an agreement with Shady Acres Retirement Home and I'm contracting for them to take care of my mother, okay? I'm a party to the contract. Shady Acres is a party to the contract. My mother is the beneficiary, and that's referred to as a third-party beneficiary. So that's somebody who is not a party to the contract itself, but stands to benefit from it. There are intended third-party beneficiaries, and there are incidental third-party beneficiaries. If I own a business on Oceanside Boulevard, and I hear that the Padres are looking to leave San Diego and build a stadium take over Goat Hill and put a stadium right off of Oceanside Boulevard. And so I go and I rent 2 more locations because I'm anticipating all of this extra business that's going to come from this new stadium. I am an incidental beneficiary in that case. I'm not party to that deal, but I'm going to benefit in some way. If then the Padres decide that they're not going to do that and they're going to stay in San Diego, I don't have the right to sue the Padres or the city of Oceanside to force that agreement because I was an incidental beneficiary. Intended beneficiaries can enforce contracts if the parties intended them to benefit. So my mom was intended to benefit from her time at the retirement home. And enforcing the promise will satisfy a duty of the promisee to the beneficiary. or if the promisee intended to make a gift to the beneficiary. So again, the deal is for them to take care of my mother. So my mother has the right to enforce that contract, even though she's not paying for the service. Assignment and delegation. So after a contract is made, sometimes one or both parties want to substitute someone else for themselves. Assignment is transferring your rights. Delegation is transferring your duties. You assign your rights, so you assign what you receive, and you delegate what you have to do, okay? And this happens all the time. My mortgage, for example. When I initially took out my mortgage, my first bank was Chase, and then they sold my mortgage to Wells Fargo. They assigned their right to receive payment. I might have somebody coming and mowing my lawn, and maybe they get busy that day, and so they send their friend Joe. That is a delegation of duties. When we look at delegations of duties, most duties are delegable. The difference between assignment and delegation is when you assign your rights, you are completely out of the deal. You are no longer legally responsible. When you delegate your duties, you are still legally responsible. So if the guy that mows my lawn delegates his duties to Joe and Joe doesn't show up, he's still on the hook for not showing up to mow my lawn, whatever that might be. He might be in breach of contract. There are times when you cannot delegate. If the delegation violates public policy, if the contract prohibits delegation, or if there is substantial interest in personal performance by the obligor. If there is some reason why I'm hiring Tom to mow my lawn because he makes really great topiary animals or he's really good at taking care of cactus, then I have an interest in his specific performance, his special performance. And he can't delegate because he has special knowledge, and that's the reason why I'm hiring him. My CPA that I hire can't just automatically give my taxes or the duty to do my taxes to someone else without my permission. If my CPA is part of a firm where there are 10 CPAs, then any of the CPAs in that firm can do my taxes. If you are delegating your duties and you want out of the deal completely, you don't want to be obligated anymore, and you want to get out of any potential legal liability, you ask all three of the parties, yourself and the other two parties, to sign what's called a novation. A novation is a three-way agreement where the obligor delegates all duties to the delegatee, and the obligee, the person who is receiving the benefits, agrees only to look to the delegatee for performance. And that releases the obligor from all liability. Don't get caught up in the obligor, obligee, delegator, promisor, promisee. That verbiage can be really confusing, but if you just think about who is in the deal and what's happening, it is pretty clear. So a party is discharged when they have no more duties under the contract. You do what's required of you and your duty has been discharged. Many times, something has to happen before you become obligated. And that is what's referred to as a condition. There are express conditions, which are clearly stated, and there are implied conditions, which the condition isn't exactly stated, but it's clear from the agreement. If I'm paying somebody to fix my car, there is an implied condition that the car will be fixed. When we look at conditions, we have a condition precedent, which means that the condition has to occur before your duty arises. So maybe I'm going to buy a house, and my offer is incumbent on my ability to get financing. Okay, I get the financing, then I'm going to buy the house. And so the offer is written so that I'm making an offer based on the fact that I'm able to find financing. A condition subsequent has to occur after a duty arises. Maybe you get a job offer for after you graduate. Okay, so upon completion of your degree, the job offer is binding. If you don't get the degree, the job offer goes away. And a concurrent condition is a condition that has to occur simultaneously. Cash on delivery. You deliver the goods, I give you the cash. Simultaneous. Moving on to performance. There are Strict performance, or also known as perfect performance. Perfect performance is you're doing exactly what is promised. Courts do not like strict performance because it tends to tie their hands. Because if you don't do exactly what's promised, then the contract isn't valid or you're in breach. And then we also have substantial performance. And substantial performance is performance that includes slight deviations from the contract, but those deviations aren't enough to materially detract from the other party's benefit. So with substantial performance, maybe it's not perfect, but we can reduce the cost of the contract based on those imperfections. So a party that substantially performs receives the full contract price minus the value of any defects. A party that fails to substantially perform receives nothing, or maybe they recover the value of their work. When we're looking for substantial performance, the courts look at how much benefit has the promisee received. If it's a construction contract, can the owner use the thing for its intended purpose? Can the promisee be compensated with money damages for any defects? And did the promisor act in good faith? In thinking about a construction contract, if I pay somebody to build my house and they build my house without a chimney, can I still use the house as a house? Yes. Okay, that's substantial performance. If they build my house and they use wood that has been soaking all winter, and so the house gets toxic black mold, can I use my house as a house? Probably not. No substantial performance. So that's the difference between substantial performance and not performing substantially. This is a picture that was painted by one of my former secretaries. She's a portrait artist. She does amazing work. And she painted this picture for one of her friends. And I bring this up and I show you this picture because artists and creatives typically make contracts that are, because artists and creatives typically make contracts that are referred to as personal satisfaction contracts. And a personal satisfaction contract basically says that I will keep redoing this painting until you are satisfied. And so what happens with personal satisfaction is that so she paints this painting and the woman says, well, I think you should paint my toenails. I don't like it. My toenails need to be painted red. And so she paints the toenails red. And then she brings it back and she says, you know what? No, I don't think I like those shoes on my feet. Put cowboy boots on me. And so she goes back and she puts the cowboy boots on. And so this can get very time consuming and very expensive to the person who is having to render personal satisfaction. So what happens with a personal satisfaction contract is basically the promisee makes a personal subjective evaluation of the promisor's performance. And what happens with the court is the court uses a subjective standard. If it says personal satisfaction, the judge is simply going to look at you and say, were you satisfied? And you're going to say no. Okay, I side in your favor. And so for a creative, one of the best things that you can do is if you're doing something as a commission, you're making a painting for somebody, you say the first 5 revisions are free, and then after that, it's X amount of dollars. And so that way, it's a personal satisfaction contract, but you are also holding a standard that says it's personal satisfaction until it's not, basically. It's personal satisfaction for X amount of revisions, and then you have to pay. Every contract imposes each party the covenant of good faith. It's really an implied condition. And basically what good faith means is that each party is going to act honestly with shared purpose. Each party is going to uphold their end of the agreement, and neither party can stand in the way of the other party. When you have a breach of contract, you generally will have somebody accusing you of breach and violation of the covenant of good faith. And then both parties typically tend to charge each other a violation of the covenant of good faith, because if there's a breach, then there generally tends to be some kind of disagreement that goes with that. And so the assumption is that they've violated their duty of good faith. Some special clauses. Sometimes you need the contract to be performed at a specific day or time. Sometimes you need performance by a specific date. Let's say that I'm having a party for my husband and I'm going to redo my swimming pool. And so I want the swimming pool done by the time of the party. The party is September 12th, and so I put September 12th in the contract. Just putting September 12th in the contract does not put the pool company on notice, because they can have it done by the 13th, the 14th, or the 16th and still substantially perform. And so if you have a specific date and you want to put the other party on notice that performance needs to be completed by that date, then the contract has to specifically state time is of the essence. You have to use those words. Time is of the essence. If you don't include that, then just having a date for performance means that the other party can still miss that date and substantially perform. When a party fails to perform without a valid excuse, that's referred to as breach. Two types of breach that I'm going to talk about is material breach. Generally, the courts are only going to get involved if a party committed a material breach. A material breach is one that causes substantial harm. An anticipatory breach is a breach that's committed by one party by making unmistakably clear that they will not honor the contract. Why would you want to breach and let the other party know that you're not going to perform? Well, they have a duty to mitigate damage, and that happens immediately upon notification that you are going to breach. So let's say that you lose your job and you know that you're not going to be able to make rent this month, next month. And so you can either tell your landlord right away, or you can wait and have your landlord evict you. Yes, the eviction process takes a long time, but every month that you are not paying rent, it's not like that money goes into thin air. It's money that you're eventually going to have to pay and owe your landlord. If, however, you tell your landlord, hey, I'm not going to be able to make rent next month, and I know that I'm going to have to move, your landlord has to act immediately to help mitigate the damage to you. They have to advertise your house. They can start showing it. You have to make it available to be shown, but they have to start mitigating the damage. Sometimes parties can't perform for a variety of reasons. This is referred to as impossibility. An unexpected event takes place that makes it really impractical for you to perform your duties. Let's say that you are delivering, that you're a trucking company, and a big fire closes the freeway. And so the only way for you to deliver your goods is to go 1,000 miles out of your way. Well, you're going to do that to your financial peril. That's referred to as commercial impracticability. And commercial impracticability is a valid reason to breach or to remove yourself or to escape a contract. So it's not just financial difficulties. There's got to be something more than that. That something has to be unexpected. And if you have to use different means to accomplish the task, go out of your way 1,000 miles. Maybe instead of shipping by air, you have to ship by truck, and it becomes more expensive. You generally have a claim of impracticability. How companies protect themselves is by including what's called a force majeure clause. Force majeure basically says that I can cancel the contract in the event of acts of gods, fire, labor disputes, transportation difficulties, basically anything that is out of my control. If you've ever been delayed on a plane and the delay is caused by weather, that's technically an act of God. Let's say that there's a 12-hour weather delay and you need to spend the night in a hotel. So you ask the airline to put you up in a hotel. The airline's going to say, I'm sorry, that's an act of God. It's due to weather. And that is the airline invoking their force majeure clause. If your delay is because of a mechanical, plane broke, that's on them. And if it's a 12-hour delay and they have to put you up for the night, they have to pay for that, because force majeure does not cover problems that are their fault. Okay. Typically what happens with a force majeure clause is if you see one in a contract for like sales of goods and you're going to sell to someone else, you have to include a force majeure clause too, because if they enact it on you, you can enact the force majeure on the party that's next down the line, and so on. We're getting to the end, folks. We are getting to the end. All right. So if you have to file a suit, there is a statutory time limit in which the injured party can file. That's referred to as a statute of limitations. The statute of limitations tends to run at the time of injury, and it limits the time that the injured party may file a suit. California statutes are different for every type of case and every type of lawsuit. I have a link in the slides where you can go and find the types of statutes of limitations. Just as an example, it's going to be different for a contracts case than it is a personal injury case, than it is for an employment case, than it is for a criminal case. And so if you want to go check out the statutes, you are more than welcome to. Link in the slides, link in Canvas, totally optional, just for your own curiosity. Okay, damages. So we talked about damages with respect to torts. And so we already know about compensatory damages, probably the most common types of damages in a contracts case. Those are the damages that flow directly from the contract, such as an order to pay what's promised, expenses caused by the breach. Consequential damages are damages that result from the unique circumstances of the injured party. Let's say that you were contracted with American Airlines to fly to Philadelphia, and American Airlines, for whatever reason, cancels the flight on you, and you now have to fly and spend the night in Dallas to get to Philadelphia. Well, the fact that you had to spend the night in Dallas is consequential to the fact that they breached the contract. Incidental damages are the minor costs that are incurred when the injured party responds to the breach, such as the extra cost of buying replacement goods. In my Philadelphia to Dallas example, maybe it's the cost of the taxi that I have to take when I have to spend the night in Dallas, so it's incidental. Okay, I have to take a taxi from the airport to my hotel. The hotel is consequential, the taxi ride is incidental. And then punitive damages are designed to punish the breaching party. Punitive damages are pretty rare in contracts cases because contracts are typically, all the terms and conditions are laid out. And generally courts assume that one party doesn't have extreme and egregious conduct, but it can happen in a rare amount of cases. Sometimes parties are suing for something other than damages. Specific performance is when you are suing for something other than money. Okay, if I think that Maricosta College has terminated me wrongfully, I can sue for money, or I can sue for specific performance. Specific performance in that case would be me suing to get my job back. Okay, so it's asking for a specific equitable remedy that is not money. Maybe there is a dispute over the sale of a house, and I'm suing for specific performance. I'm not asking for money, I'm asking for the house. Reformation is a process in which the court will rewrite a contract that might be vague, it might be unenforceable. It might be that the two parties agree that they want the contract rewritten, and so that process is referred to as reformation. I already talked about the duty your landlord has to mitigate damages. That's not just the landlord, that's any party. Once one party knows that the other party is going to breach, they have a duty to mitigate damages, and so they can't recover for damages that could be avoided with reasonable efforts. And then nominal damages are a token sum such as $1 that is given to a plaintiff who demonstrates breach but no serious injury. Gwyneth Paltrow was in a lawsuit relatively recently. She had an accident on the ski slopes, I think in Park City or somewhere, with somebody that sued her. He was suing her for like $500,000, lots of money for injuries. She countersued for $1. And the countersuit for $1, which she won, was nominal. She was just trying to prove that she did nothing wrong and that she was making a point. I have a great nominal damages story that I will share with you on another video. A liquidated damages clause is a provision that states in advance how much you're going to have to pay if you breach an agreement. Generally, liquidated damages clauses are only enforceable if at the time of creating the contract, it's difficult to estimate what actual damages would be, and the liquidated amount is reasonable in nature. All right, we're here. End of lecture. I'd really like to think that you got a lot of stuff out of this one. If you didn't, I'm really sorry. Go back and watch it again and maybe get something. But honestly, this is a big one. This is an important one. I gave, this is probably like 4 lectures enclosed into one giant topic. So do yourself a favor and go watch this again, or sit down and really like process those notes. Have a great week.